we talking about sexual harassment? Sexual harassment is still a very alive issue in the workplace. I know from professional experience that it's still very much a live issue. You know, we get a huge amount of claims through our team, and many of them do have an element of sexual harassment. And I know that some employers are very proactive about this, but believe you me, some aren't. And just very quickly looking at this is a survey, admittedly, it's sort of 4 or 5 years old. And it says that, you know, nearly a third of people in employment have suffered some form of sexual harassment, most common being unwelcome sexual jokes and unwelcome staring. And it's important to remember this isn't just an issue that affects women. It's almost equal, 30% of women, but 27% men said they'd suffered some form of sexual harassment, although arguably different types. But there's a real problem with employees reporting this. Only 15% of individuals said that they actually reported it, which makes me worry that actually that 29% is a lot higher. I suspect it's a lot higher. In fact, I anticipate that of people in this room, I imagine most, if not all, have either been subject to or have witnessed sexual harassment in the workplace. I mean, I really do think it's that prevalent. And it can be low level, but it still can be unlawful. There are various bars to people reporting it. They're worried that their job's going to change. They're going to suffer from a detriment. You know, 40% of victims saw their job change in some way when they reported it. 17% looked for a new job. Nearly half felt that felt that action hadn't been taken against the perpetrator. But if we move on and just sort of go back to basics, and we'll look at the law as it is now and how you can protect yourself now. So if we just look at what sexual harassment is, it's defined in the Equality Act. It's where somebody engages in unwanted conduct of a sexual nature and conduct that has the purpose or effect of violating somebody else's dignity or creating an intimidating, hostile, degrading, humiliating or offensive environment for that person. It's important to remember it's very easy to fall foul of this, actually. You don't have to intend sexual harassment for it to occur. If it has that effect of creating a degrading or humiliating environment, it's nevertheless sexual harassment. So the typical example is workplace banter, sexually based or, you know, racially based, can have the impact on somebody listening in who wasn't the intended recipient of those comments. They can still feel and indeed can pursue a claim. You don't have to aim personally sexual harassment. Having an inappropriate conversation in the hearing of somebody else can constitute sexual harassment. And it can be things like sexual comments and jokes, suggestive looks, leering or staring, propositions, sexual advances, intrusive questions about someone's sex life, sexual gestures, sexually explicit messages or texts, unwelcome touching or hugging. Again, it's important to remember somebody can be sexually harassed by someone not just of a different sex, but of the same sex. And employers are liable for the acts of their employees and agents, people doing things on their behalf. So an employer will be liable if their employee engages in sexual harassment. And those who are protected by the law aren't just employees, it's workers, job applicants, contractors, even former employees. All of these people can potentially bring claims against an employer to say that they've been subject to sexual harassment. Now, there is a defence in law, and I won't stick too much on the law because you want to hear practical stuff, says that if an employer takes all reasonable steps to prevent that specific act of harassment taking place, they are not liable for it. So somebody brings a claim saying, I've been sexually harassed. The employer says, I took all reasonable steps to prevent that particular act of harassment taking place. They can avoid liability. Very few employers will run that defence because it's quite difficult to win. So that's the sort of law. But you will, I hope, be aware that the law has changed. It developed in October so that we're not just dealing with acts that have happened, but there is a new preventative duty which came in October, which says that all employers now are under a duty, a proactive duty to take reasonable steps to prevent sexual harassment happening in the workplace. So that is a proactive duty. It applies to all employers, large and small. And if you don't comply with that duty, damages can be uplifted by up to 25% if an employee brings a successful claim. So let's look at it in a bit more detail. In order to comply with this preventative duty, as I say, you have to take reasonable steps to prevent sexual harassments of workers in their employment. What is reasonable will vary from employer to employer. The law doesn't list specific steps that you have to take. Different employers may prevent sexual harassment in different ways, but the point is all employers do need to take action. And whether or not a step is reasonable is an objective test, and it will frankly depend on the facts and circumstances of each case, and each employer's situation will be different. It'll depend on a number of factors such as the size and resources of the employer, the nature of the working environment, the nature of the risks that are present there, and the time and the cost and the disruption of taking a particular step weighed against the benefit that it could achieve. So there are various factors, and it's important to note as well, this is not just we take steps and that's it. You need to look at whether steps you've already taken have been effective. So if somebody brings a claim, you then need to go back and go, well, actually, have the steps that I've already implemented, are they reasonable? Could I do more? Do I need to be looking at this? Do I need to be taking alternative action? So it's a developing and ongoing duty. The duty is to take reasonable steps, not currently all reasonable steps, but I'm going to come back to that. But it's a general duty. It's not a duty in respect of a specific perpetrator. It's a wider holistic duty, looking at your workplace. Where are the pockets of risk? What can I do to mitigate that risk? The summary point is that if somebody brings a claim for sexual harassment and they are successful and you are found to be liable, and you obviously haven't run your statutory defence, the tribunal will then look at the extent to which you have complied with this new preventative duty. And depending on how far you have fallen short of what they consider to be reasonable, they can uplift the award of compensation by up to 25%. Now, damages for sexual harassment, they're often not huge. They often may only be sort of a few £1,000s. Sometimes they can be much more substantial than that. But the point is that will be uplifted if you are not complying with this duty by up to a quarter. And it's not just the financial damage, it's a reputational risk. It's bad enough having a finding that you're responsible for an act of sexual harassment in your workplace. But to then have a finding publicly that you failed in your duty to prevent sexual harassment in your workplace, that's a really bad reputational piece, because it sort of signals to the world at large that you're not taking steps to prevent the well-being of your employees generally, and in particular, protecting them from sexual harassment. Just a few points to note. And there are a lot of unanswered questions here, because this duty is relatively new. We're not seeing much in the way of sort of judicial decision on this yet. As you may be aware, there is a huge backlog in the employment tribunals. So we don't have much in the way of judicial guidance. So, there are issues. If not all reasonable steps, how many? One? Two, some, most, and where you're looking at employees, how many of your employees? All of them, most of them? You might have employees working in different areas of your business. You might have some that are office-based, some that are warehouse-based, for example. There may be different risks in those areas. Are you going to apply a blanket approach, or are you going to sort of split your business off and take different steps for different groups of people? Don't forget, the prevention is not in relation to specific sexual harassment by a specific individual. It's a wider duty. It's looking at preventing sexual harassment holistically at large. What if a specific sexual harassment case has been brought and you have actually taken steps to address that, but it's happened, but you haven't taken wider steps? Where does the liability sit? Does the judge say, well, you've taken steps to prevent this particular act, but we still think you've fallen short elsewhere? You could still be vulnerable to financial penalty. So there's a huge amount of uncertainty here. But let's take a look at the way that you may be able to protect yourself in respect of the law as it is. Now, the Equality and Human Rights Commission has published some really, really helpful guidance on this. In particular, there is an 8-step guide, which is online, that they have set out 8 steps that you can and indeed should be taking now to comply with this duty. And I'm just going to sort of run through these to see how you can implement these steps in your business. So the first one is developing an effective anti-harassment policy. Now, I'm sure that most, if not all of you, will have some form of policy, whether it's an equality policy or, a dignity at work policy. But you do need to review this if you haven't already, and really make sure that it's fit for purpose to enable you to present to a judge, should you have to, that you have taken reasonable steps to prevent sexual harassment. So your policy needs to be clear who it applies to. As I said, it will apply to your employees, but also workers, contractors, job applicants. It's got a wide reach. It needs to state that you have a zero tolerance attitude to sexual harassment. Goes without saying, but it does need to be said. It needs to say that there will be consequences if somebody is found to have committed sexual harassment in the workplace, and reference your disciplinary policy. And it needs to be clear that you'll take into account aggravating factors. It may be, for example, that you get somebody that commits a low-level act of harassment, which in itself is probably not worth more than a first warning or a letter of concern, but they keep doing it. Or it may be that there is, for example, a power imbalance where somebody of seniority has harassed somebody quite junior. You'll have to take all these factors into account and make your policy clear that you will look at this in a nuanced approach. You need to make clear what sexual harassment is. As I say, it's actually very wide-reaching, and make clear that it's not, you don't have to intend it, you don't have to intend an act for it to be sexual harassment. And you also need to be very clear how you're going to receive and respond complaints. And this links to the underreporting that I talked about earlier. There is a huge amount of underreporting, and you need to try and combat that by being very clear about how you are going to deal with and respond to complaints, and provide reassurances that anybody that does bring a complaint will be treated with compassion, with confidence, and won't suffer any detriment. The policy should be clear and available, and not just sort of hidden somewhere on your intranet. It should be a live document. You should regularly signpost your employees to it. I mean, as an example, we had an employment team away day last week, in fact. Now, you'd think that a bunch of employment lawyers would be kind of alive to the issues of sexual harassment, and wouldn't be likely to act in such a way as to be deemed to be sexual harassment. But we nevertheless all received a copy of the policy before we had the away day. That's not because our bosses think we're going to sexually harass each other, but because, my employer needs to show that it is taking a proactive approach to preventing sexual harassment, and regular signposting to a policy is a good way to do that. And as I say, you do need to update this policy at regular intervals. I'd say at least annually, monitor its effectiveness and implement any changes that might be required. As I say, it's a live document. The next step is engaging with staff. This sort of goes beyond the policy, having regular one-to-ones, staff surveys and exit interviews. Speaking to people is a really good way of flushing out where there may be issues of sexual harassment in the workplace. It may not have escalated, but it's a great way to nip it in the bud. So speak to your staff, both face-to-face, but also anonymous surveys and that sort of thing. You really need to sort of find those red flags before they become tribunal proceedings. And obviously, as I said, make sure staff are aware of how to report sexual harassment. So again, that doesn't just have to be in the policy. You can engage with staff in their one-to-ones, in their staff surveys to reinforce that point that you will listen and deal with reports, and that people can report such acts safely and in confidence. And this isn't just down to the HR team. Everyone says, "Oh, it's for HR." This isn't. This is a cultural piece. All line managers should know how to deal with sexual harassment. It's not just for HR to deal with. And this is actually your key starting point: risk assessment. I don't think you can defend or have a decent case to say that you've taken reasonable steps to protect your workforce if you haven't even undertaken a risk assessment. So to me, this is step one. If you haven't done anything, this is what you really need to be looking at first. You need to identify the potential risks in all areas of your business, and there might be different levels of risk in different pockets of your business. You need to assess steps, work out the steps that you could take to mitigate those risks, then consider, are those steps reasonable? And if they are, you should implement them. Simple as that. But you do need to consider various things that might give rise to risk. So power imbalances are mentioned. Are junior staff vulnerable to more senior staff in any areas of your business? Think about things like job insecurity. How do you mitigate the risk of people not wanting to report because they're worried about the repercussions on their own job security, issues with their colleagues if they report? Look about presence of alcohol goes without saying. That's an obvious area of risk. Out of hours working and even home working, attendance and events, socializing outside work. And don't forget, it's not just a sort of person-to-person, sort of in-person risk. Social media is a big risk. So how are you going to protect your employees on social media or in emails? And as I say, poor culture. Do you have a poor culture? Do you clearly say we stand against sexual harassment from the board right down to junior employees? You need to have that culture pervade throughout your business. And some of my clients are actually engaging in cultural reviews to look at their culture to make sure that there are no sort of toxic elements there that and to make sure that their culture really does portray that message that you will not condone any inappropriate behavior. Actually, whether it's sexual harassment or not, inappropriate behavior will not be tolerated. This needs to come from the board, and it does have an impact on your bottom line, which is one good way to get the board's message if you want to get buy-in from them. The next couple of steps, reporting. As we've talked about reporting, people reporting to you, but make sure you do have clear reporting systems in place. And as importantly, keep centralized records. Don't just deal with an issue and then disregard it. You need to have centralized records so that you can build a bigger picture of what's going on in your business. Are we getting more complaints from a particular area or in respect of a particular individual? You need that bigger picture to be able to continue working on your sort of risk assessment and taking steps to mitigate risk. So keeping records is important. Obviously, be mindful of confidentiality and data privacy, but it is important, I think, that you do keep an audit trail of issues that arise in this space. And training goes without saying, but this needs to be more than just tick box. It needs to be more than just a one-off training. You need to regularly update your training. We have to do sexual harassment training once a year, all of us, even the employment lawyers. And it's not just line managers. Any member of your staff can commit an act of sexual harassment and leave you on the hook for it. So this isn't just training for line managers and HR, it's training for everybody. But equally, you do need to train your line managers on how to deal effectively with complaints if they land. Moving on to handling complaints. First thing you can do is ignore them and put them in the slightly too difficult to deal with pile. And it happens, and that's where problems. I'm often brought in once a line manager received a complaint, hasn't dealt with it properly and promptly, and it's escalated. And 2 times out of 3, it will end up in a tribunal. The key to nipping things in the bud is to take action promptly. Once you get a complaint, deal with it proactively. Respect confidentiality. That's really important. And the victim needs to know that they will be protected and that this will be confidential. But it's not just about the victim, and I think sometimes people forget this. It's also about the alleged perpetrator. The difficulty with sexual harassment is often a case of he said, she said, or she said, or he said, he said. There are no witnesses. So you can't just jump to conclusions and immediately remove the perpetrator or take any sort of sudden knee-jerk actions. You need to take a considered response before you take any action in respect of either party. This is a huge well-being piece. It's very stressful for people to be accused of having committed sexual harassment, particularly when it's not true. And people do raise untrue allegations. It's very difficult to navigate for employers. I do understand, but there are well-being issues here that you need to have in your mind when you're dealing with these things. In serious cases, you might need to consider whether you ask the victim whether they want to report to the police. Now, you obviously can't make them, but it might be appropriate to suggest it. And another thing is, once you've had a complaint and you've dealt with it, do feed back to the complainant. Now, you have to be a bit careful because if you've subsequently taken disciplinary action, that is confidential in respect of, that's confidence around the perpetrator. You can't go back to the complainant and say, oh, yeah, and then we gave so-and-so a final written warning. That's private. But you do need to give some feedback to give the reassurance that you've dealt with matters and also say, if this occurs again, come back to us. So these are all important things that you need to think about when handling a complaint. And also harassment by third parties. I'm going to talk a little bit about this at the end, but make sure that you've got mechanisms in place to prevent third party harassment. That there isn't actually a standalone legal case you can bring in respect of third party harassment at the moment. But if you are complying with your wider duties to protect your workforce, then really that should encompass looking at the risks that your employees might be subjected to in dealing with customers, clients, suppliers, members of the public. but I'll come on to that a little bit later, well, shortly actually, and just talk about developments in law in that respect. Now, this is an ongoing piece of work, as I say. You can't just update your policy and that's it, leave it there. You need to be constantly reviewing your systems and your processes that you put in place to prevent sexual harassment. So you do need to sort of undergo a constant process of spotting trends, reviewing your informal and formal complaints to see where those trends are arising and to consider whether there are any further steps that you can take to address them over and above those which you might have implemented during your first sort of go at this. Surveys, as I say, I've mentioned them, but have continual surveys. Make this a sort of standing question in your staff surveys about whether they've been subject to or witnessed harassment. You need to know this. People might not have reported it, but if people have witnessed it, you need to know that these things are happening, where they're happening, how they're happening, and again, what steps you think you can take to address that. Triangulating sounds very scientific. But what I mean by that is simply looking at the reported complaints that you've got, those that have been officially reported, against the sort of more anecdotal evidence that you might get in your staff survey. Is there a correlation? Is more harassment being reported anonymously via staff surveys than you're actually receiving by way of the formal complaint process? If there's a sort of disconnect there, why? What steps can you take to encourage people to report more? And learning, use past experiences to inform future actions. You need to hold lesson learned sessions. If you do have a complaint or indeed a tribunal claim that has an element of sexual harassment, learn from past mistakes, because the tribunal will expect you to have done so. They will expect you to be proactive. If you get a complaint of sexual harassment and there's a finding against you, a tribunal, if you get a subsequent complaint, will say, well, what lessons have you learned? And if you haven't learned from them, you haven't taken reasonable steps. So these are all sort of key things that you can be doing now and should be doing now, in fact, to protect your business in respect of the law as it currently is. As I say, I've talked about where we're at now, but things are going to change and things are actually going to become potentially far more difficult for employers. You'll be aware of the Employment Rights Bill. This was published last October. It's undergone various sets of amendments since it was published, and it is a sort of slightly moving feast. But what we do know is that there is still an intention to raise the bar significantly in the sexual harassment space. We don't know yet when this is coming in. It's probably not till next year, so we have a bit of time, and we still need guidance as to how this is going to work from a legal perspective and a practical perspective. But ultimately, the preventative duty is likely to become not just reasonable steps, but all reasonable steps. Now, that's a difficult concept, because what is all reasonable steps? How far do you have to go to comply with all reasonable steps? And again, we're waiting for guidance on that, but it significantly raises the bar, and this is coming. So you do need to be thinking about it now. And it links back to what I said at the very start, which was talking about the statutory defence, where an employer can say that if they took all reasonable steps to prevent harassment and therefore they can avoid liability. But as I said, very few employers run that defence. I've even had a judge say to me when I've tried to run it on behalf of a client, are you sure you're really going to run that? Implying it's almost impossible to comply with, which is very much at odds with the new proactive duty that employers are going to have to comply with under the Employment Rights Bill. There is a real disconnect there. But I would say, as I say, this is a bit pie in the sky because it's not in yet and we're still waiting for more guidance. But I would say, knowing that this is coming down the track, if you go back to those 8 steps that we've just talked through and go through them comprehensively and regularly, I'm not sure there's much more that you can do in order to comply with this all reasonable steps test. So I'm thinking if you just focus on those 8 steps and make sure that you really integrate those into your business as a sort of regular review, then I think that is likely to give you as good a chance as any of complying with the new, more onerous duty that is coming down the track, probably next autumn. But, watch this space. And I would just say that just a couple of quick final points on the Employment Rights Bill in respect of sexual harassment. Sexual harassment is now going to have whistleblowing protection. At the moment, somebody who raises an allegation of sexual harassment isn't protected by whistleblowing protection, which means there isn't a sort of freestanding claim if they suffer a detriment or are dismissed as a result. But it's going that they will now be treated as whistleblowers. And so there will therefore be legal protection where somebody raises a complaint of sexual harassment, they will be treated like a whistleblower. The other thing just to mention is that it also means that NDAs about sexual harassment complaints will be completely unenforceable. So there's a couple of other developments that are coming down the track under the Employment Rights Bill. And then very finally, third-party harassment. Now, the current position is that an employer is not liable for third-party harassment. So if their employees or workers, apprentices, whatever, if they are subject to harassment by a third party, they're not liable for that. There is no claim that their employee can bring. Now, there's a wide range of third parties if you sit down and think about it. Customers, clients, self-employed contractors, service users, patients, students, friends and families, delegate at a conference, members of the public. It's anybody that isn't an employee, basically. As I say, there's currently no protection. They tried to introduce it under the Equality Act, and that was repealed. They made another attempt to bring it in under the Worker Protection Bill, but after debate in the House of Lords, it was removed. However, it's back. I would just say, though, don't forget the EHRC general guidance that although there's not a freestanding complaint in law at the moment, you should nevertheless look to mitigate the risks of third-party harassment on your workforce purely to create a safe space for your employees to work. So it's a general duty, doesn't give rise to a claim. But that is going to change. The Employment Rights Bill is going to introduce the concept of third-party harassment as a claim in its own right, which means that an employer can be liable if a third party harasses the employee in the course of their employment and the employer has failed to take all reasonable steps to protect that employee from that third party harassment. Now, this to me is going to be really difficult because an employer, whilst they may be able to issue policies and procedures and training and staff surveys to their own employee cohort, they have very little control over how a third party acts. Whether that's a customer coming into a shop or a supplier dropping something off or whatever, they have very little control over how that third party acts. And one example that I've heard sort of bandied about is somebody working in a pub or a restaurant, and there's a group of customers having a private conversation amongst themselves, which may be very offensive and create an intimidating and hostile environment for the employee who's serving them, even though they're not party to that conversation. But that could in itself give rise to a claim under these new proposals. So I think it's going to be very difficult to control, very difficult to police. I don't know how judges are going to deal with this. I don't have any answers, unfortunately. I'm sort of raising the spectre of this rather onerous duty, and I don't have any answers at the moment. I just wanted to put it on your radar because it is something that you can at least start to be building in to those 8 steps, as the EHRC suggests anyway. Look at not just where your employees may be exposed to risk from other employees and workers, but where they may be exposed to inappropriate behaviour and conduct by third parties. And if you're already building that into your processes, then at least you are some way towards protecting yourself when this new duty comes in, say, at some point next year. So, great if you've taken steps to address sexual harassment in the workplace already. If you haven't, now really is the time to start. And if you already have, review it. As I say, this is an ongoing duty. So continue to revise update your risk assessment regularly. Have a mind to third-party harassment while you're doing that. And if you do that, I can't think of anything more you can reasonably do. And don't forget, even though the new duty is going to be all reasonable steps as opposed to reasonable steps, which is where we are now, the key is the word reasonable. It's not all steps, it's all reasonable steps. So that is one saving grace, I think, in this current and indeed new, more onerous duty. But it's something that you do need to be proactive about and you do need to be thinking about now. And just the final slide, there is a lot of useful guidance out there. There's some more detailed technical guidance for employers that the EHRC have published. It's really good, and that probably is your starting point. You know, if you're kind of fairly new to this